Land contract issues? We got a land contract, we find one?
I did, Judge, and we sent that over to the court, so you should have a copy of it there.
Okay,
And paragraphs G and H of that land contract address the issue. Plus, I submitted a memorandum of law. And the law is real clear that Mr. Miller really has no legal claim.
okay, so, yep, let me just actually oh, here's your memorandum. And you said the land contract's in here someplace too?
Yes, we sent that over, Judge.
Okay. Let's see if I find it.
And I would advise the court that Mr. Miller dropped off some tax returns to our office yesterday. We asked for his email and he said, just mail it. So we overnighted some stuff to him. I don't know if he got it yet or not, but
Hey, Mr. Miller, why don't you unmute as well there for me, just so I got you on.
Your Honor, if I may?
Hold on just a minute. Let me just kind of see what I've got here.
Yes, sir.
Got the trust. Assignment of land. Seller's interest in land contract. Browser, oh, looks like I've got, oh, here, this is it. I was gonna say the only thing I don't have is the land contract, but I might have it here. I think this is it. It's tax documents.
I can have it sent over again, Judge.
Yeah, boy, you've been good enough to send everything else over here. I got to be in here. What was it attached to? I've got an assignment of seller's interest in land contract. I do have that.
Yeah, the actual land contract, we managed to find that and we did send that over.
Okay. If you want to, rather than me trying to, if you can just email that part of it over to me.
Yes, if you'll excuse me, I'll go have my.
Sure, and it's good. Just do it to Janet again. Dries.
Okay.
Yeah.
The original? I don't think he sent it to me.
No, but I'm having him do it. You know what, Mr. May, I just found it.
Yeah, Jack, he just found it.
Yeah,
Jack.
Yeah, he just found it. Oh, never mind, Tammy, they found it.
sorry. Yep.
All
Mr.
right.
Belzer, I did find it. It was underneath the other paperwork for some reason.
Okay, good.
I do have it. So, okay. All right, so I guess let's just start from square one again. We'll start completely over. I do have the documentation. Mr. Belzer, Mr. Miller, I kind of cut you off. What did you want to tell me before we start? Was there something before we start?
Your Honor, I would like to ask the court if I could move to dismiss this matter on the basis I was never provided a notice to quit. I have some support I would like to offer for my motion. A notice to quit is required in most circumstances with a few exceptions. One, after forcible entry. Your Honor, I came under color of title pursuant to the lease.
I don't think we're up to that part yet. Let's just see how the land contract part goes in first. You know, they're suggesting they have a land contract to the property. That's what they're saying.
Well, is there anywhere on there that there is an encumbrament on the property?
There's what?
Encumbrament on the land contract?
An encumbrament? Encumbrament? Is that what you're
Yes.
talking about?
Yes, sir. Yes, sir, Your Honor.
Well, we haven't got to that point yet. Let's just kind of go through, Mr. Belzer, let's just go through like we would a normal hearing again, because now that I got all these documents, let's just do it, okay? Mr. Belzer, do you have a witness here? Why don't you go ahead and,
Okay, I'll have Mr. May, who was previously sworn.
yep, we'll just, Mr. May, why don't you raise your right hand there? Do you swear from the testimony you're about to give me the truth?
I do.
Okay. Mr. Belzer, if you could just kind of lay all the facts out for me, and we'll do it.
State your name for the record, please.
Jack Douglas May.
And Mr. May, you caused you owned this particular piece of property at one point in time personally, is that correct?
I've owned it since either through my corporation or
No,
myself.
my question is, you owned it personally at one point, or did a who owned it first when you bought it?
Corporation, the
So
corporation
your
owned it first.
corporation owned it, you subsequently transferred it to a trust that you have,
Yes, it did, yeah.
and it came to pass that you did a land contract with your son Brian, is that correct?
Yeah, the corporation did the land contract and I assumed it.
The corporation did the land contract with Brian, is what you're saying,
Yeah,
correct?
that's right.
And then subsequently, the corporation conveyed this property to your trust, and the trust now owns that deed to that property, correct?
Correct.
And on that land contract, we provided the court a copy of that. And that's the land contract that you entered into with your son Brian, correct?
Correct.
And he failed to make payments on that contract, is that correct?
Yeah, he's never made a payment, which I didn't enforce that, but okay, yes. No,
Okay,
never made a payment.
and so subsequently, in lieu of court proceedings, your son Brian signed a deed giving that property back to you, is that correct?
That's correct.
And at the current time, you have the deed to the property. The land contract has been extinguished by virtue of the last quitclaim deed from Brian, is that correct?
That's correct,
And your son Brian's here also to testify if need be, correct?
right? That's correct.
And you had no dealings yourself with Mr. May or Mr. Miller. You didn't enter a contract with him. You didn't enter a landlord tenant arrangement with him, nothing, correct?
I had no dealings at all, no.
Judge, and that's the testimony I need from Mr. May, from Jack May. And the land contract is in fact with the court, as well as the deeds that show the transfers back.
Did you have, yep, and I've got the assignment. I assume what you're talking about, Mr. Belzer, is the assignment of the seller's interest in the land contract?
Yes, yes.
Do you have that? And that's dated this, boy, 31st day of December 2005. Is that right?
Right, that's when it went from the corporation to the trust, is that?
That's correct, yeah. The
Okay.
of the year.
Into the trust, so that's that date. So we got December 1st, 05, and then the land contract we had. In the land contract that was in effect, I'm sorry, you started, Mr. Belzer, with regard to actually, we probably should have these submitted as well, as long as we're doing this properly. Are you asking me to review the land contract, the assignment that we just discussed, and the quitclaim deed that was just testified to?
Yes, Judge, the land contract was dated July 27th of 06.
Okay.
And then the quitclaim deed that deeded it back after that forfeiture of the land contract is dated February of 15. No, is that right?
Yeah, that's correct.
Yeah.
I didn't deed it until later. I missed on doing that.
So I've got I guess, Mr. May, for my benefit, the land, all these documents, the land contract that you just testified to has your signature on it. Yeah, May Homes and Realty by Jack D. May, and that's your signature that's on that too, that's dated?
Yes, it is, yes.
Okay. And then on the quitclaim deed that's dated February 10th, 2015, that's also your signature, Jack D. May, quitclaim it over
Yes, it is, yes.
the trust? Okay.
And Judge, then, if I may, there's also
Sure.
the deed from Brian. Satisfaction of the land contract that's dated August 14th of 2024.
Oh, and I did see that too, August 14, 2020. Let's see that. There it is, I believe. Bells, you just hold with me. It's August of 2024. Is that what I'm looking for?
Yes, Judge.
Where am I gonna find that? Which I thought I saw it at one point. Is it attached to one of the other ones or what am I?
Yes, Judge, that was filed early on.
Okay, oh, maybe it's in the file still then. Okay.
With the original complaint that was attached, Judge.
Okay, let me look back in the. Yep, here it is, August 14th, 2024. And it looks like that was recorded as well. So I do have that document as well. The quick claim to Jack D. May, trustee of the revocable trust. That's the one we're looking at.
Yes.
That was dated August 14th, 2024. Okay. Mr. Miller, any objection to any of these documents?
Your Honor, Michigan law,
Exhibits?
Bob,
Hold on. And any objection to these being admitted as exhibits?
no objection, Your Honor.
Okay, so we've got exhibit. Let's just do this in some kind of nice orderly fashion if I can figure it out. How about, for both of your sakes, exhibit 1, the land contract dated July 27, 2005 will be exhibit 1. Yeah, that'll work. That's admitted. Then we've got assignment of seller's interest. I'm just going down what's attached. Assignment of seller's interest in land contract to the trust. That's dated December 31st, 2005. That'll be exhibit 2. And that's admitted. And we've got the quit claim deed from Mr. Jack D. May to the trust itself. That's dated February 10th, 2015. That'll be exhibit 3. Is that right? Exhibit 3, that's admitted. And then exhibit 4, quit claim deed from Brian May to Jack D. May as trustee of the revocable trust. That will be exhibit 4. Exhibit 4, and that's admitted. Mr. Bowser, does that cover the exhibits that we need right now? Is that right?
Yes, Your Honor, yes.
Okay, so those are admitted, and Mr. Belzer, I guess if we've got other testimony, do you have other testimony right now, Steph?
Well, not at this point. I mean, if Mr. Miller wants to raise this $144,000 question, I have Mr. Brian May here to testify that that never happened.
Okay. Okay, so Mr. Miller, are you going to testify?
Your Honor, Michigan law 554.134 requires a notice to be served on a tenant. Proper notice is conditioned precedent to a summary proceedings action. Park Forest of Blackman versus Smith 112, Michigan. Park Forest held that the landlord's failure to comply with the notice requirements of the state deprived the district court of jurisdiction to hear the case. As a result, I am entitled to due process, which requires a proper notice to quit be served. And without proper notice, the court lacks jurisdiction, and this case should be dismissed.
So the only thing that you're arguing, Mr. Miller, is that there's this lease agreement? Is that right?
Your Honor, I have a valid lease agreement with Brian May.
Okay,
And
do you want to
plaintiff,
test it? But we're not even at that point yet. I've got a land contract that's sitting here that they're arguing supersedes all this stuff. If you want to testify and tell me why this lease agreement that you're talking about is legitimate, we can do that. Is that what you want to do first?
why would I have to testify about a lease agreement that I'm agreed on the lease agreement with? I don't understand.
They're saying it's not a legitimate lease agreement.
Your Honor, I have a valid lease agreement with
Okay,
Brian May.
I know what you want to argue about, but do you want to testify and tell me why this is a valid lease agreement or not?
No,
Mr. Bowser?
Well, Judge, if that's his position and that's the end of the proofs, I submit to the court that we are entitled to possession of that property, that Mr. Miller is a trespasser.
objection, Your Honor.
Mr. Miller, you're kind of getting yourself in a jam here. I've got nothing else here. Yeah, I'm gonna take a brief recess off the monitor. I'm gonna get the pleadings actually in order too. Give me just a minute here. All right,
Okay, sure,
hold
Judge.
on.
Thank you.
All right. Okay, we can go back on the record. Mr. Belzer, I did find some orderly fashion to the exhibits. On the land contract that's been admitted, it's July 27, 2005. Is there language in here, can you point me directly to it that says that the land can't be encumbered by purchaser, that being Brian May?
It
Is there
was
a place in there?
subparagraphs G and H, and I'll get that language here.
Okay, G and H,
Yes.
okay.
In paragraph G, 1, 2, 3, 4, fifth line, fourth line down. That the purchaser and any other occupant, remove and put out.
I'm sorry, which paragraph are you on? What,
On G, the small g,
in section purchase agrees, it's two,
that would be in section 3. I'm sorry, Judge.
Oh,
Section
3?
3G,
3G, okay. Should,
the third and fourth line of that paragraph.
purchase seller. Conditions,
And also paragraph F, I said H, but it's really F.
okay.
But G is the main one, Judge.
Okay.
And as noted in the memorandum that I filed, Judge, because the land contract itself was never recorded, and the deeds were, the deeds take priority and the unrecorded interests really don't count. I mean, that's
Yeah,
a brief summary.
okay. And so that's the second prong to this thing, basically.
Yes, Judge.
Yeah, okay. Okay, and so the only ones that were recorded are actually the quitclaim deed.
Yes, Judge. And Michigan being a recording title state,
And we're talking about, I see, here's the issue I got with it. So the ones that were recorded, I do have the one that's kind of after the fact of this alleged lease agreement is a quitclaim deed that's Brian May to the trustee dated August 14th, 2024. Is the other, what else has been recorded?
prior to that, the two deeds for Mr. May is corporation to his trust.
Okay, okay. Those are back in, if I remember right, I thought I saw 2005 or something, right?
Yes, Judge.
Okay. Yep, here it is. The one that goes from May Homes to the Jack D. May Trust. Is that right?
Yes,
Okay.
Judge.
Yep. And that's dated December 31st, 2005. Okay. And with that, Mr. Belzer is, so I understand the lease agreement that was submitted, is that, Mr. Miller, did you submit that to the court or was that given, did Mr. Belzer, did you submit that? The alleged lease agreement, the one's dated July 1st, 2024. Ooh, that's from,
We had a copy. I don't know if we submitted it.
Mr. Miller, did you submit that from, it says landlord Brian May, property lease type to you? Did you give me that or did somebody else give me that? It's the lease agreement that you're arguing. You're muted.
Yes, Your Honor, I'm here.
Okay, was that your lease agreement that you submitted to the court or did it came in on August 30th, 2024? Is that from you or?
I'm not for sure, Your Honor. I know the police station, the Flushing Police got a copy of the Michigan residential lease agreement. I don't know if I brought that copy in to you or not, Your Honor.
Okay. It's got some blue highlights on it. I don't know who highlighted it in blue. It's got some. Well, I don't mind, Mr. Miller, if you don't want me to even look at this right now, it's not admitted, the lease agreement. You want me to consider having it admitted as an exhibit, I don't mind doing that, but
Yes, Your Honor.
if you want to do that, before it sounds like you didn't want to even do that, but do you want to try to get that admitted or not?
Yes, Your Honor.
Okay, Mr. Belzer, just for the sake of the record, I got my hand, it says Michigan residential lease agreements dated July 1st, 2024. It's from landlord Brian May to tenant Taji Miller, and this is one that has created all these issues as well. Mr. Miller, it's dated July 8th, 2024. Is that your signature on this?
My signature is on the lease, Your Honor.
Okay. And what about Brian May?
Brian May's signature is also on the lease, Your Honor.
And kind of, maybe I'm throwing you off too, Mr. Belzer, but do you have a copy of that lease agreement?
I have a copy, but according to what I've been advised by Brian May, there was other language in that lease that's not on the copy I have.
Okay. Oh, boy, we got two different versions of it now. So, okay. The one that I've got in my hand that was in the file, it's got like 39 paragraphs. Maybe we can start out there. Maybe that's,
Yeah. Yes, that is correct, Judge. That's what I have.
okay. It is Brian May with you, you said? Is he gonna
Yes, Your Honor.
testify at all? We might as well, as long as he's here, we might as well, one of you. Mr. Miller, are you gonna testify at all or not?
Your Honor, I'm a Michigan residential tenant. I don't think it's required by law for me to testify.
Okay, you don't have to. Then, Mr. Belzer, do you want Brian May to testify with regard to this, I guess, this lease agreement? Or any agreement?
Well, Judge, I mean, if there's no other testimony except what we presented, I don't see the need for that.
Oh, that's true. I guess that's true. Maybe I'm going overboard on it, I guess. Yeah, I guess you're right. If it's not admitted, it's just not admitted. I guess I don't have a real lease agreement in front of me.
It is admitted.
It is admitted, Your Honor. You just admitted it.
No, I didn't. I didn't admit it yet. It has, no foundation's been laid. Nothing. No-
Your Honor, you asked me did I want to admit it, and I agreed to it.
Yeah,
On
so
record.
that's why I'm trying to go through proofs for you to get it admitted, and you said you didn't want it and you didn't want to testify, so we're kind of past that. You just told me you didn't want to testify, so. Mr. Belzer, let's go back to your complaint here. How has this been filed? Well, I guess, Mr. Belzer, if we just want to give me final argument, I'll review the documents that have been admitted and we'll go from there.
Judge, basically, Mr. Miller is there under no claim of right. He has no claim to that property or to be in that property. And we just asked for an order of possession of that property and evict Mr. Miller.
Okay. Mr. Miller, anything else you want to tell me?
Yes, Your Honor.
Okay.
Your Honor, I would like to ask the court if I could move to dismiss this matter on a basis I was never provided a notice to quit. As a result, I am entitled to due process, which requires a proper notice to quit be served. And without proper notice, the court lacks jurisdiction and the case should be dismissed.
Okay. Mr. Belzer, why should he have a notice to quit? Or maybe he shouldn't.
Well, he should, Judge. I mean, I think the law is real clear. I mean, he has no claim of right, and my review of the law does not require that he be given a notice to quit. And
Yeah. Yeah, but I did get a chance to review all the documents. I'll come on just a minute. Let me make a decision. I'll come right back on. Okay.
thank you, Judge.
All right. All right.
Put the mic off.
Okay, let's go back on the record again. Jack D. May revocable trust versus Taji Terrell Miller. Had a chance to review the exhibits that have been admitted in this matter. As far as my notes with regard to testimony, I do find that I'm going to go through documents first. There was admitted Exhibit 1, land contract dated July 27th, 2005. That land contract was between May Homes, and I'm abbreviating names, but May Homes as seller and Brian May as purchaser. There is some language in that land contract that says this property cannot be encumbered by the purchaser, and the purchaser being Brian May. One portion in particular says in it's a paragraph, purchaser agrees, paragraph 2 of the land contract. And for the record's sake, this has not been recorded, which is another element in this, but was not recorded. But it does state under paragraph 2, subparagraph D, Purchaser agrees to keep and maintain the land and the buildings in as good a condition as they are at the date hereof, and not to commit waste, remove, demolish, or improve thereon, or otherwise diminish the value of seller's security without written consent of the seller. Throughout this contract, if there's any changes in the state of the property that diminishes the value of the seller's security, that has to be in writing. There's nothing in writing that's been submitted today that there was written consent by the seller to somehow diminish the value given what Mr. Miller has testified to, this excessively long lease agreement that he's referred to, which has not been admitted, but he's stated that there was a lease agreement to, it's a long-term lease agreement for, I think it was 60 years. Yeah, July 1st, 2024 through allegedly ending July 1st, 2085 with monthly installments of $1,000. It significantly diminishes the value or the seller's security in this property. There are other provisions in this land contract that state very clearly that the property cannot be encumbered by the purchaser. Again, if you have nothing in writing that says that the seller, and again, that being at this point on the land contract, May Homes, gave written consent to have this property encumbered, thus reducing seller's security in that property. Should be noted there's also a quit claim deed that was recorded. It was quit claim deed on this same property from May Homes Realty to the Jack D. Mays Trust. That was dated December 31st, 2005. I've heard nothing as far as testimony that disputes that ought not to have been able to have happened. That was recorded. I'm sorry, that was not recorded, but that was going into the trust, and then there is the actual quit claim deed dated February 10th, 2015, that quit claimed May Homes interest in this same property on Pine Needle Trail that's at issue for today. Quit claimed it to the Jack D. May Trust. On that date, it was recorded February 13th, 2015. That by itself says the recording, since it was recorded, it's the Jack D. May Revocable Trust that is the owner of that property at that point. I've heard nothing to dispute that, other than we've got what Mr. Miller purports is this alleged residential lease agreement. Heard no testimony. Mr. Miller refused to give any testimony with regard to that lease agreement. He wanted to argue that he did not receive a notice to quit, but given all of the documents, there was no lease agreement that was enforceable on this property. Brian May, in fact, also the Exhibit 4 quit claimed his interest in this property. Now, it was after the fact. The purported lease agreement is dated July 8th, 2024, but Brian May did, for whatever reason at that point, quit claimed any interest he may or may not have to the May trust on August 14th, 2024 on that document as well. But that was after the fact. If the lease stands, I find that there was no enforceable lease at this time. That property could not be encumbered by Brian May. And in fact, given the testimony I've heard as well, Brian May was in default on this land contract that was not recorded. Anyways, no action was taken from the being the familial relationship between Brian May and Jack May and the revocable trust that was established. No action was taken because, quite frankly, this property had already been deeded over, claimed over to the trust on February 13th, 2015. That's the only document that's been recorded. The credibility of that document stands beyond everything else that I've heard. And therefore, there's no lease agreement in its entirety. And Mr. Taji Miller is a holdover person on this property, not even a tenant, quite frankly, based upon all of the documentations and all the testimony that I did hear. Given the fact, though, that Mr. Miller has been on that property for a period of time, I will give him is he on that property now still?
Yes, Judge.
I'll give him the statutory 10-day period to move.
We'll prepare the appropriate orders.
Okay, very good.
Thank you, Judge.
You're welcome. Good luck to everybody.
Thank you.
All right, you're welcome. Good luck, Mr. Miller.